can the Supreme Court issue a ruling on that 14th Amendment Section 3 case as early as Friday with an unnamed author of the opinion? I mean, we see them time and time again, actually. Team?
Yes, the answer is yes. It's called a per curiam opinion, which is Latin, which means through the court. In other words, the justices all agree. No one particularly signs off. I mean, nobody appears as having rendered the opinion or delivered the opinion of the court. It just says on the top, per curiam, through the court. And it would be a very narrow, in my view, opinion in which every justice would sign off on it. And it would probably be on the question of the president is not an officer.
Yeah.
And that's what I think every justice could agree on.
Yeah, per curiam opinion would be showing unanimity, which I think is important in these kind of cases. But it would be, Harry, on the most narrow of grounds, I would think. And that's fine.
I think that is correct. And certainly for those of us that have listened to the disqualification hearing, it's possible to argue that the Supreme Court's analysis, questions, and the like reformulated Jonathan Mitchell's argument to the court, because Jonathan Mitchell was arguing on behalf of Donald Trump, but the Supreme Court was providing several bases for a decision favoring Donald Trump, meaning that he would not be disqualified from pursuing his candidacy as president. However, Jonathan Mitchell, as many people have noted, refused to accept the Supreme Court's invitation to take yes for an answer. So I think a per curiam opinion would suit the Supreme Court very, very well, and no justice would need to be named with respect to the decision.
And then you don't have the politicization of an issue like this at the court. But let me tell you what else could happen here. That's on the 14th Amendment. On the immunity issue, they could just deny the stay with one sentence. The motion for stay directed to the court is denied.
Absolutely. And I would say right now that may indeed be the most likely outcome,
I think that's right.
In part because President Trump's lawyers refused to offer a middle ground to the Supreme Court. And a middle ground would simply ask the Supreme Court to formulate the correct tests for presidential immunity going forward.
Exactly.
Because the test offered by the prosecution and accepted by the Second Court of Appeals basically exposes each and every president at the termination of his or her presidency. They are then exposed to liability.
You know, it's like a basketball game. You're down to the buzzer. You're down by one. You got your main point guard is ready to make the shot, a layup. And instead of going for the layup, you say, I'm going to go for the three-point play. And you go for the 3 point. You didn't need the 3 points. Right. You just need the case to go back to the district court for determination of whether it's official acts or not. And I just think the strategy there was lacking. These are smart lawyers. I'm not questioning they're smart. John Laura, who's running that legal team, is a very good lawyer. And Sauer, who's the Supreme Court lawyer on that one, was the Supreme Court lawyer from Missouri. So was their Solicitor General. They're smart. I just would have gone a more I think the word I would use is a little more calculated approach, not make the court reach so far to come out with a conclusion that's beneficial to you.
Right. Question on Rumble, too. Could you explain why the 14th Amendment case is not a state sovereignty issue?
That's a great question.
Didn't come up a lot in the case. Colorado tried to issue a little bit, but
it's not because the federal elections are uniquely federal responsibilities, and the qualification clause is a clause of the U.S. Constitution. And a state cannot change the qualifications for president because they want to, because that would create election chaos. And when you look at the 14th Amendment, the disqualification for insurrection actually can be lifted by Congress on a 2/3 vote. So it's a uniquely congressional responsibility.
States get to set up the elections. The Supreme Court's interpreted that as procedures, like do you need signatures, how much to be on the ballot. Nothing, not ideological,
substantive changes that would affect who qualifies as quote qualification as
so
qualification.
They all are a little different. So every state is different on how you qualify.
Yes,
both in the primary and the general, but all procedural. It's not substantive, and that's where the distinction is as well. If the Supreme Court does not grant any kind of stay
in the immunity case,
how soon could that trial begin in D.C.?
I think June.
So they've got to go through they'd have to go through a jury.
Jury selection could start in June. I mean, if Judge Chunkin states with her original rule, which was for every day of delay since March, whatever the date was, I'm adding a day to it, and you're 2.5 months out, I think you go from middle of February to the middle of March to the middle of April. So I think sometime in May the case could start.
So there you go. I mean,
then the question is, at that point, what is the political ramifications of that? And that we are I think we're in uncharted territory. What do you think the court's going to do on this immunity claim in the way it's been phrased right now, Harry?
Well, I think the Supreme Court will deny the claim made by Trump's lawyers, in part because they were too ambitious, and they may simply issue a per curiam denial.
Yeah, that means they could do a per curiam denial for a couple of pages. They could issue a one-sentence order that says the application for stay referred to the court by Chief Justice is denied.
Right. So, I mean...
And it could be tomorrow, too, because the issue is joined now.
Right. I mean, so that, I think, again, puts President... I know there can be, other procedural matters that go along with that, but that's when you got to get into the voter's mind. Because so far...
Well, that's your ball game, too. I mean, what do you think? They say it affects 4 or 5%. That's enough to sway an election.
It is. And I think right now, the persecution feeling of President Trump is the reason why he's gone up in the polls and why he's kind of run away so far with the Republican nomination and is doing pretty good against these matchups with President Biden in the swing states. He's actually made big improvements there if you look at where he started. But that was when the cases were just getting filed. And a lot of people thought, well, will they ever actually make it to trial? And there were some questions about that. The classified one, that's way behind. That was the first one that came through.
Sure seems like that one's
doesn't seem like that one's coming anytime soon.
But the Alvin Bragg case, we're going to talk about that with CeCe Howell coming up.
Yeah.
That one may well come up.
Right. So there's the Alvin Bragg, and then there is, of course, the one around January 6th. I think the question would be it probably won't affect the primary voter because you won't have any convictions or not guilty.
Not certainly by Super Tuesday.
But you might have convictions by November.
Yes.
And that might freak people out because, especially the criminal matters.
You're saying because they think at that point, can the president actually govern?
Can you govern as a convicted criminal? And where are you if you're a convicted criminal? Are you governing from a special prison or at the White House but house arrest? Can you travel to other countries? I mean, it just brings up a whole host of issues we've never had to deal with in our country, and neither have the courts.
No.
So these are, if he got found guilty of 3 of the 4 counts that Jack Smith bringing, I mean, that would put most people in prison for 20 plus years.
Oh, yes, 94 counts.
So,
if you look at
but
all
if
the
he wins
together.
as president, what happens then? I mean,
well, I think
it's
part of
unprecedented
Judge
territory.
the longer this goes, though, you start getting closer, Andy, to that 90-day rule. Now, in the state court
crisis.
proceeding, by the way, doesn't have that 90-day rule. That is strictly a Department of Justice policy.
That's right. That's a policy that was enacted by the Justice Department, I think, in 2005 or 2008, that you don't do anything within 90 days of an election that may have election that may be outcome determinative or consequential on an election. That's right.
So again, I think when it comes down to it, we will quickly get into the voter mindset in some of these primaries coming up on Super Tuesday.
We only have a segment left, but I would like to ask our audience this. If there was a conviction of the former president, how does that affect or not affect your voting? If the president was actually convicted on January 6th trial, how does that affect how you would vote in the general election?